So my name is, as you can read, Julian Nowag, and I'm an associate professor at the University of Lund, which is the picture you have behind me at the moment. I am currently not in Lund. That's why you only have the digital picture behind me. I'm currently in Oxford, where my family lives, and I'm this year also teaching competition law for the students here. Yeah, so that's what I do. I'm originally German. I have studied law in Germany. The first couple of years, I did an exchange in the beautiful country of Austria. And you think like, oh, why would a German go to Austria? That is like, is that not nearly the same? Well, if you ask the Germans or the Austrians, in particular, the Austrians will tell you that is absolutely not the same, and they are right if they say so. But why did I go to Austria? Well, I was studying in Germany, and I thought that we were getting so bad grades in Germany. It was so difficult to pass, and even more difficult to get a good grade, that I thought if I'm going to go to the UK, where I wanted to go, then I'll never be able to pass any exam if I'm already struggling in law to pass a basic I don't know, criminal law exam. I have struggling in passing that. How can I pass that in a different language? So for that reason, I chose to go to Austria, where I at least didn't have to fight with the English language. But as you can hear, I overcame that fear of the English language at some point and went to study in the UK. And I went to study first for a master's in LLM in Durham, in the north of the UK, and then a PhD, a master's and a PhD at Oxford University. After that, I went back to Germany, did a bar course, so I'm a qualified lawyer in Germany as well, and then started to teach at Lund University, where I teach European business law. I'm the director of the Master for European Business Law, and I teach mainly stuff related to European business law, competition law, state aid, internal market, things like that. So I think that's more or less what I can tell you about myself. And if you have questions about my academic career, which might be interesting to you, feel free later to ask me anything. So as part, I think, of this journey across different jurisdictions, I came to see quite a different variety of ways of writing in law. The Austrians, they write already different to the Germans in law. And then the British, they write differently altogether. Swedish, as I usually say, somewhere in the middle, but they are still much closer to the Germans than, for example, to the English. I'm not here to tell you what the best way of writing is, and I think that is something that is important. I'm just telling you about one way to write, and whether that is the best one or not, that really depends on the context. And I think it also depends on what you want to do with your writing. What is your aim in writing? What is your aim in legal writing or legal academic writing, which I mainly do? Sometimes I also do court submissions. They are slightly different, or legal opinions for law firms or so on. The idea is different, so you write different. But for me, what the aim is of all this writing is the effective communication of ideas. If I'm writing something in law, whether that is academic or more kind of practice related, it is always that I want to effectively communicate what I have in here. I want to talk about what I think, and I want that presented in a way that it arrives there with you, the reader. So I think in that sense, communication is here the idea, or at least that's what I think is the aim in writing. And if you are an artist, then certainly it's different. You want to write beautifully, Maybe as a lawyer, you want to write also beautifully. But for me, I still think my primary aim is to communicate effectively what I'm thinking, and so that you have the same ideas in your head that I have in mine. So, how do we communicate? We communicate with language. And quite often, or at least in my case, we have to communicate in a foreign language. The funny thing is, with foreign languages, at some point, it gets easier for you to communicate in a foreign language than it is to communicate in your own native language. I had that because after some time of teaching European competition law, I had to teach, or European law, I had to teach European law for the first time in German. That was so difficult. And I actually made a couple of mistakes in my language that I would not have done in English. So it's a foreign language, but it's my working language, I would say. So if you are going to start out in communicating or in writing in a foreign language, let's stick to English. But I think the same would go for German or French, if that would be the language of your choice in which you want to write. I think it's slightly different if you're writing in your own native language. That might be more difficult or easier, but I think we can all learn something from that. And I want to make here 2 points about writing in a foreign language. One is related to understand, like basically both points are related to how easy it is to understand the ideas that you want to communicate. So the first is related to sentence length and sentence structure, and the other one is related to structure of the text itself. So sentence length. I remember when I started studying law, and I heard from Rahil that some of you have been studying law now for a couple of years, others have just started rather recently. But I remember the first 2, 3, 4 years when I studied law, my sentences would become longer, and little monsters. And I think that might work, and you might be getting really good at this in your own language. If you're translating that into a foreign language, it doesn't work that well. Because you're not so used to the structure of the sentences. Where do you put the verb? Where do you put the subject of the sentence? How does it work best with commas and semicolons, and how does it work with subclauses and so on? So that relates to structure of the sentence, but it also relates in particular to length of sentence. So I would advise anyone who writes in a foreign language to keep the sentences short, to the point. Start a new sentence as soon as possible. And if your sentence is just 4 words long, that's perfect. There is nothing wrong in communicating easily, as long as the message gets properly received on the other side. For me, I have my own kind of personal rule, which is if I write a sentence in English and the sentence is longer than 2 lines, I pause and I ask myself, is there a reason why this sentence is that long? Can I shorten this sentence? And only if there's a specific reason, a specific justification why this sentence needs to be that long, only then I'll keep it that way. Otherwise, I'll find a place where I can put a full stop in the middle of the sentence somewhere and start a new sentence. That makes it easier for the other side to understand what I'm saying. So that's the first part, that's related to sentences. And the second part is related to structure, but I'll come back to that in more detail later. But the point here is also structure is important. How you structure your paragraph. Do you have paragraphs in the first place? that relates to effective communication. That relates to helping the reader on the other side to make it easy for them to follow your thought, to follow what you want to tell them. That's what I think the ideal thing of writing should be, that the person on the other side is able to follow what you're saying. So think about that in terms of structure, or ask yourself, if you're getting an A4 piece of paper and it starts in the top left with a word and it ends in the top, in the bottom right with a full stop, and the rest of the whole sentence of the whole page is just full of words, how easy will it be to follow that compared to a A4 paper that has maybe a heading, a nice paragraph, a bit of space, another paragraph, another heading, another paragraph, another 2 paragraphs, and so on. So think about that. You'll give the reader space to breathe, to think, to digest what you have been, or what they have been reading, what you have been saying to them. So I think structure of how you structure a document that you're writing in English, in legal English, is also important. And then that relates, I think, to language and to cultures, given that we're here from different countries. There are different ways of in the way that we write in different countries. And just as people are different, writing styles in different countries are also different. And I would always say, and I think those who have been with me in my class will have heard that before and maybe get bored from it. There are many ways in terms of writing that lead to Rome, but some are the highways and others are not highways. So I'm going to present you, I think, later with what I think is one highway to Rome, to the destination. Okay. So that is what I want to say in a broad overview. Let's look in a bit more kind of concrete things, and then I'll talk to you, and you tell me a bit about how you would write it. But let's think quickly what the core question is. Writing, I think, is a task that, at least for how I see it, is not so much about you. It's not about you showing off. I know that some of my colleagues might be able to disagree with me in this regard. They might want to show off how skillful and great and knowledgeable they are. I don't think that's the purpose. As I said already, my understanding of writing is I write not to show off what I know. I write so that you, the audience, understands. I write to communicate ideas, my ideas, so that what I have in my mind somehow, ideally as close as possible, appears also in your mind. And that is, I think, what is important. The important thing here to keep in mind is what you say is not always what arrives on the other side. And I think keeping that in mind will make you a bit more focused on how you say things. If you write, you should basically think, okay, how will another person that sits on the other side reads this? How will they receive it? And is the stuff that they are receiving the stuff that I want them to receive? And that then leads us back to questions of structure, right? If you have written this kind of nice text and it's all kind of brilliant ideas, but it's a text of one page, maybe even more pages, without any paragraph break or whatsoever, that might be amazing. But it might not be so amazing for the person that reads it, because they just don't have any space to think, to pause, to understand where one thought ends, a new one begins, and so on. So it might be very difficult, but it might still be brilliant. But it can be even easier for the other person to understand your brilliance if you have nicely structured the sentence and the overall document. That leads us again back to the final point that I wanted to make, and then we can talk a bit about it. Structure of legal documents. So we can think about different legal documents. We can think about legal documents in general. We can talk about academic documents. We can talk about non-academic ones. Think about blogs as non-academic pieces that I, for example, write. If I write a legal brief for a court or a lawyer or a company, what do I want to do? Well, I want that those people that read it to understand what I'm telling them. What are the legal dangers, problems here? And what typically you will see is the people that are reading these legal briefs might be the specialized lawyers, yes, but quite often they are also like very busy people. There might be executives, maybe only executive of the law firm, but whatever, or of the company. But they want to have quickly the most important things on their hands. What is this all about? Why is it important to me? So that's how and why a lot of these documents have executive summaries, which are essentially short summaries of the most important points. And quite often, these people are never going to read more than that. For more details than that, they just don't care. And they don't need to care, because they can pass on the more detailed question to the lawyer. But maybe if you can convince them in this summary that they need to pass it on to a lawyer, then you have done an important job. You've also done an important job if that executive summary tells them only, yeah, there are like a couple of things, but in general, you don't need to worry about anything. Then you've also done exactly what they want you to do in a short kind of executive summary. Then let's move on into academic work. And then I wanted to move slowly on into communicating with you guys and seeing how you would write academically. And then I'll tell you how I would write academically. But how would you write academic work in your jurisdiction? What is the kind of expectations that someone would have? How would you structure that? And I think when we talk about structure at sentence and document level, there are quite different expectations in different jurisdictions. I'll talk about that in a second. And then you have the non-academic writing. So I give you my example. I write a blog. What does the blog post do? The blog post is essentially a summary of my academic work for an audience that is either, ideally, I write for people who are non-lawyers, that they can also understand what I wrote in this strange, obscure journal about competition law and something. I want to translate that essentially into a way that normal people can understand, but also might be interesting for other academics if they want to have a quick look or so on, and other law students like yourself maybe. But I, in this case, want to make sure that the general public would also be able to follow me. So I will write differently. Okay, so if we are now going back to academic work, and then before I open the floor and I ask you where you're from and how you would write, and feel free to contribute or not. Quickly, something about academic work, and that has to do with academic standards. So I think what, in a certain way, distinguishes academic work from non-academic work is questions of plagiarism. Academics take plagiarism rather seriously. So no quote can ever be there without a quotation mark and without a reference to where you got that from. Why is that? I always say, well, academics, they are a bit, how should I say? We don't get paid that much. It's all about reputation. And if you steal our work, well, we don't have much else that you can steal. So it is about acknowledging the work that people have done. Otherwise, that's why you put a reference there. So I think maybe that's why in academia, people are a bit more serious about plagiarism and copy and pasting than they are in other parts of the legal profession, where lawyers might provide a document to their client that basically is a copy and paste of the last document they had. That's perfectly fine for a lawyer and their client because it's a different purpose than an academic journal. So I think there are questions that are specific to academic writing and that relate to referencing, quoting, and plagiarism. But that's kind of the more formal side. I think the other side is, how do you, so if I give you an academic question, and that's, I think, already something, you can distinguish between different forms of academic writing. If I write an academic article, or you write the answer to an exam question, that is different. And even within the exam question, you can distinguish between what we call problem questions. So do you have a case? I don't know, let's take criminal law, because we have that all in the different jurisdictions. So the case that the accused A was in a night in a pub, did drink 10 beer, and afterwards he used a baseball bat to hit someone on the head. Is that a punishable offense, and what offenses are punishable? That is a problem question. Or you have a question that might be a question of what we call essay question, which then might say, well, the European Union, give you again an example, is not an international organization, but a supranational institution. Discuss. And now, if you know something about the European Union, then you can discuss it. If you don't know anything, then you cannot discuss it. But I think what you see here is that there is one question, and you have a rather broad theme to discuss here. So those are kind of two exam-related things, while the second one might be much more closer to, if I write an academic paper, it might be why the EU is not a international organization, but is much more a supranational national organization. So that might be a paper. Or what paper have I recently I wrote a paper called Quantum Antitrust. So that looked into what quantum computing means for, or could mean for, the application of antitrust law. And we just thought about what it could mean. So that's a different way of writing. And then you can structure those things in different way. But I think like the second part of the exam question and an academic paper, there might be much closer related, where you try to provide an argument, provide an analysis, and so on. And I think there are many ways how you can structure this. And I think that's, if you talk about legal academic writing, that is more what we're talking about, rather than problem questions. So if you had to say that the European Union is a supranational organization and not an international organization, how would you argue that, in not kind of in terms of the content, but like, how would you structure something like that in your jurisdiction? And where are you from?
Should I start?
Yes, you start.
So I'm from Azerbaijan, and coming to the question, it's actually a good question. I remember this kind of question quite related to this one in one of our exams in the European Business Law program. But I would structure it mostly giving a bit of introduction of European Union, how it works, generally the system of the legal system of the European Union. Further moving to making arguments, like dedicating one paragraph to arguments for and arguments against. This is the structure that I always use, and it mostly works well. So yeah, that will be my way of writing, just saying. But before moving to other people, I would like to ask one question.
Yes.
It really interests me a lot, and it's about your teaching at the University of Oxford and at Lund University too. So how do you think, what's the difference between students, generally international students? For example, at Lund University, there are mostly non-European, non-EU students too, but most probably at the University of Oxford, the people are a bit of different. Coming to non-EU students, I mean, how do you think generally their writing styles, writing techniques, and generally academic stuff, how do they prefer using writing techniques generally? So like if we have a comparison between these two universities and their students, how would you describe it?
I think like what you will see is that in Oxford you have more common lawyers, meaning lawyers from common law jurisdictions. That's New Zealand, the US, Canada, Australia, obviously, Hong Kong, Singapore to a certain extent. Then you will see, for example, in Oxford, then in Lund, where you also have a lot of internationals, but like the kind of, it seems more in Lund seems more that you have, how many do we have this year or in your year from Azerbaijan? 3, 4, something like that. And then you have 3, 4 from another jurisdiction. While here in Oxford, they have the luxury of being able to say, well, I'm not going to take more than 2 students from country X, and for that I take 1 student from this, and so on. So the variety of students is bigger. But coming back to this kind of common law variety. So in Lund, we don't get many people from Australia or New Zealand, or sometimes we get people from the US or the UK. So that changes because like common lawyers are much more used to, when they're studying law, typically I teach in both cases, only master students. They have already had their training in legal writing in a certain way. And the way that I teach in legal writing to the master students in Lund is much closer to the common law style. So if you have more common law students in a class, then more people will already be used to that kind of style of writing than the other way around. So I think that's one of the main differences.
Yeah, thanks.
Yes. So who else is here? Where are you from, and how would you write? Yes, please.
I'm not sure. Hello, I'm not sure. There's different of noise.
Yes.
Yeah, great. So I'm Rigan. I'm also from Azerbaijan, but right now I'm studying in London. So to answer your question, I think I'd also first start by looking words like European Union, giving a description, and then I would also like structure it in a way that first I will explain what we understand by international organization. When we say international organization, what we mean, because you can mean a lot of things. And then I would say what is then supranational, and at the last part, I would explain. I would look like European Union, under which category European Union more fits. So that would be my structure. I think that's the first thing that came to my mind. Yeah, I think I tend to be a bit overly descriptive in this case, so description is very important for me. So I think that we should understand, we should be on the same page what we understand this thing. And at last step, maybe we can see, okay, now we have given all the description, now we can say which one causes I think how I write that.
I'll just make quickly a note. Because you said something that I wanted to not forget. Anyone else who wants to contribute how they would do it in their home jurisdiction and where they're from? We don't have to. We don't have to. That's perfectly fine. But as I said, like we have like different ways that lead us to Rome, and I think like you already heard two closely related ones. Obviously, you're more or less trained, might be in similar ways, but they're already kind of different. And I think my point here is, again, that it's not there's one way that is right and one way that is wrong. My point here is about clear communication. So if I would have to read your essays, I would certainly could follow your structure. However, what would make it much easier for me, and that's what you want to do, not only as an examiner, but also for the reader, it's like, I want to be able to follow you, what you are saying. How can you do that? You can do that by telling me very clearly at the beginning, how is your essay structured? You said like, I'm going to provide an introduction. Yeah. What are you going to tell me in the introduction? Like, rather tell me first how you're going to structure your essay, and then I can easily, for example, if I already know what the European Union is and when it was founded and so on, I don't need to read this. Maybe I'll just if I have to mark it, okay, then I might need to read this and see whether you have made any mistakes. But if I'm reading it because I'm an academic, I'm not interested in the history of the European Union. But if you told me that you start off with the first paragraph or the first section, and you might ideally have also a heading, then I can already skip that. And I'm like super happy, because then I don't have to read, I don't know, 2 pages of stuff that is actually not relevant to me. And then you're explaining to me what an international organization is. And I say, yes, that's important. I know a lot about it, but because your argument relies on this, I'll have to have a quick look at this. So if you already told me the next part you're going to do is like determine the most important features of an international organization versus a supranational organization, then I say, okay, this one, I know the difference myself, but it's important for the following arguments. I'll have a look at this. So I'll read a bit more. Well, the first one I might have jumped over completely. The second one I might have read in a bit more detail. Then comes the kind of third part, and that's the actual interesting part, right? That's the actual part where you're making an argument, and that's what we lawyers do. We make an argument for or against something. The previous part is what you said, descriptive. You like to be descriptive. We all like to be descriptive. In some jurisdictions, we are trained to be extremely descriptive and not to take any sides. But at the end, we are lawyers. We need to decide. Either we are judges, and then we need to decide. We cannot be just describing something. We need to decide. Or we are advocates, and then we need to argue for one or the other side and say why one is right and one is wrong. So the interesting part for all lawyers is the last part, where you essentially say, okay, I have like provided you with like a broad overview, whatever. I've provided you with a basic definition of what one versus the other is. And now I'm going to tell you why it does not fit, or does fit one, but does not fit the others. So that's the important part. And you want to have that also clearly set out. That is one thing. So having that clearly set out, I'm just writing a couple more points after that I wanted to make when I hear you speak. So we have now looked a bit into the structure. So we have heard how you can do that, and I think it all sounds extremely well. If you want to read it and you want to follow the arguments that those two have made, I suggest to you that it would be much easier if they had headings or subheadings even, where I as a reader could follow it and say, okay, these sections are interesting. This is something, an argument that I can easily agree with. I don't need to read it in detail because I fully know that they are right in this regard. But this one is something where I'm not so sure. I need to be convinced. So I want to focus on this one. So headings really help me in following your argument. And then I have followed your argument and I come to the end. And now again, there are different ways to structure things. So let me go back. I'm originally a German lawyer. When we in Germany used to write things, and we didn't used to, we only used to do problem questions, we had to write in a very deductive style. Meaning you would have to ask a question at the top and say, well, if so-and-so hits so-and-so on the head, then it could be an assault. And then we would have to define. An assault is defined in the following way. 3 conditions. Each condition and then follows. The first condition is defined as. The second condition, and then we would say, well, this is for these reasons it is fulfilled, or these reasons it's not fulfilled. And only then at the very, very, very last point of that whole paper, you would read the answer. And the answer would be, yes, this is an assault because he has hit the other person with a baseball bat on the head. So you would not know at the beginning where you end in the end. And a lot of Germans' academic writing is sometimes still like this because they have learned that so much when they studied. I learned that when I studied. It's supposed to be there to train your thinking. But at the same time, it's not necessarily particularly good in communicating your thoughts. If you want to convince someone, that might be not the best thing to do. It might sound particularly neutral, particularly scientific method to do. But then, like, I'm starting to read and I'm like, I know how battery is defined. I don't care about it, the definition of battery. I just want to know why, in this case, it's an assault or not. So I think here communicating, reading from the introduction, telling what you do, saying, for example, in our case, and I said it again, and I've said it before, but I say it here again, I'm just telling you what I think is good. There is no objective way of knowing it, and it might be like, for example, if you would write a piece in an exam in Germany in the way that I'm now describing, it would be marked as failed. But I'm not in Germany, and I'm trying to tell you how to write an academic article and be trying to be convincing. So you would have an introduction that tells you, well, I'm going to tell you why the EU is a supranational organization and not an international organization. I'm going to structure this in the following way. And then we have these lovely structures that we heard from your 2 colleagues. And at the end, you need to have a conclusion, which reminds the reader, yeah, it's true. They quickly told me a bit about the context and the definition of an international organization, and then they made 3 points. Yes, very important. Conclude your legal piece. And that brings me, I think, to 2 more things that I think are important. One has to do with word limits, or words in general. And it's connected to the number of points you make, which is my second point. So word limits. Think about, we sometimes don't have any word limits, but somehow we are always limited by words or time or space. So if I'm writing an academic article, most of the times I don't have a word limit. Some journals still have word limits, some don't. But let's assume I don't have a word limit. There's still some kind of limit that I have, right? I don't want to write a book for a journal article. So that means that I have a total amount of 100% of words that I can spend. And now I need to think about how I'm going to spend this wisely. Am I going to spend 70% on the history of the European Union or not? I would suggest if you are trying to argue about whether the EU is an international organization or a supranational organization, then spending 70% of your time, space, or words on the history of the European Union is not a wise choice. You should make sure that you spend those words wisely, because words, time, space, whatever you have, think about what is the important part. Or if you are thinking about exams, where will I get points for? That's where I want to spend my time, my space, my words. In this case, reasons why it is an international organization or why it's not an international organization and why it is or is not a supranational organization. Yes, you also have to define those terms, but that's also not the main contribution that you are making. So thinking about how you're going to spend your words. And that leads me again to the final point that I want to make, and then we can just open the floor and discuss a bit freely, which relates to the number of points you're making in a piece. So you can make, let's assume this, again, this article about the nature of the European Union. You can make 10 arguments, or you can make 3 arguments. It depends now on how much space you have, how much words you have. But if they are limited to a certain amount, then making 10 points seems to be clearly excessive, because that means that you will just have 1 sentence, 2 sentences on each of the points, so you cannot really dive into any detail. And detail is the stuff that makes a convincing case. If you think that I'm saying the EU is an international organization, for example, it does this and that, the for example is the important part. That's what makes it convincing. If I don't have the example, that is just a statement. And if you have 10 statements lined up after each other, that's not particularly convincing, even though you might have covered and know a lot about all these areas. It might make much more sense to limit yourself and say, I'm going to focus on the following points. 3, I love 3. I like to make 3 points. But that's something that I think you need to take into account, and you need to balance that and place it into context of the overall structure or length of the piece that you're going to write. Yes. So those are, I think, a couple of points, and thank you for your contribution. I think they made a lot of sense and helped to put the whole thing a bit to life. But I'm now open to all questions, whether that is legal writing, academia, studying, or whatever.
May I?
Yes?
So as I mentioned before, my main problem is kind of, I try now not to be too descriptive in my writing. I say that it gets longer and it doesn't really make sense because I just give a lot of description. So what I understood from this session is that if I have a clear argument before I start writing, and I just work it into the headline subheading, would it help? I mean, when I'm even given the description of what is international organization, I think I should keep in mind my goal, my aim, my argument, and then kind of lay the foundation already when I'm just describing. So it shouldn't be just a description, but it should actually serve your point, your argument. Right? And then if I avoid just giving general things, and I just stick to the points that actually serve my, then I think it would be better if I
Yes,
understood it.
I think that's a very good point that you're making there. You want to ask yourself, is that what I'm writing relevant to the point that I'm trying to make? And there might be things about international organizations that are very important to what you're going to argue, and other points that are completely irrelevant. Let's assume, I don't know, the first international organization, I'm not an international lawyer, so please excuse me, was the League of Nations. You can write that. It's obviously, maybe it's right. Let's assume it's obviously right, but it might not serve your argument at all, so why write it? And especially if you think about like how you spend your words, write about those parts that are important for your argument. And I think one point for people that are struggling with the descriptive part is all what you write might not necessarily be wrong or not needed. Sometimes it's just about the structure, how you describe it. So your description of the European Union might be very not needed and superfluous in the overall background or whatever. But it might, if you use that, exactly that, let's assume you have written it already, and someone says you should rewrite it to make it, because up there's too much in that description of the European Union. You can possibly copy and paste that sentence from up there down in the argumentative part, and there it supports your argument, and even though it's just a description of how the facts of the European Union are. And now suddenly it describes some element of the European Union, but it's part of your overall argument. So it's just literally a question of where and how do you place it.
Thank you very much. Another thing is that now I'm going to write my thesis to complete my master's. But I always have this doubt. If I make an argument and then I go do my research, field work, and then actually discover that not the case, I discover things that go against my argument. I'm always very afraid of this, that I spend all this time making arguments and start reading my writing on that, but then suddenly I discover something else, like how we could avoid it, or maybe we should not avoid it. We can somehow, like, I don't know, work in it and adapt it. What would you recommend on that?
That is, I think there are a couple of things. I give you the lawyer's answer, depends. And I'm going to try to give you the good lawyer's answer and tell you what it depends on. I think as an academic, it depends on whether you are suddenly convinced of something else. Then it's exactly what you should do. You should write a thesis, and then if you find out that it's wrong, then you change it. That's what you should do as an academic. On the other hand, you're like a curious person. You want to like find out the truth, whatever that might be, but like some kind of right or wrong or something like that. But on the other hand, you might have written an argument and then you find something that contradicts your argument, but it doesn't necessarily mean that you've changed your opinion. It might be just a counter argument, and then you can come up and say, okay, I have said this, but we need to take this into account. But on the other hand, there's the counter argument, and that's why I'm still sticking to my current one. You can do that also very nicely in your thesis. So if you're writing your thesis, I think thinking about the structure, collecting, while you're collecting, make sure you always mark anything that you copy and paste already in a different color, already with quotation marks, and directly write the reference behind it, because you don't want to end up in a situation where you say, oh, this was somewhere in the pile of books on my desk. I don't know which one. So do that. And yes.
Also another thing, I'm sorry, have a lot of questions.
Apparently the other ones don't have any, so yeah, they would have to raise their hands otherwise.
Yeah. Another thing is that I feel like there can be a lot of counter arguments to the argument that I'm making. But maybe I'm not exhausting all the way. Like maybe I'm not addressing all of them. Not all of them come to my mind at the moment I'm writing. And then maybe I go to defend my thesis, and there are points that I have overlooked. So it's something also like I'm very kind of now that maybe I'm not seeing from all perspectives. So how also we can maybe deal with it like before we start, like what we can do, like is it literature review, do more or something else? Maybe that can help.
So look at me. I said, how often today? I'm just telling you one way to Rome. There are numerous ways to Rome. That might be good, might not be. You might have a different view. I think that's just the nature of things. We are unsure about what we do. And the funny thing is, I forgot how the rule is, but it's called, there's a rule for this. Basically, those people who know very little about things are very confident about what they know. But the more you learn about something, the less confident you become about what you're saying. So this doubt is not necessarily something bad, it's something normal. And you will not be able, you need to accept that you will not be able to cover all the angles. Like today in this talk, I didn't cover all the angles of good writing. I'll have forgotten some, there are some counter arguments that should completely destroy my argument here. Maybe they are, maybe they're not. I hope not. But I try my best.
Thank you. That's nice.
Excuse me, do you have time for a question or not?
Yes.
Okay, sorry. So first, thank you so much for this wonderful speech. So my question is about the difference of publishing of journals from the North American context and European context, because according to my observation, I feel like many journals, particularly those student-run journals in the North America, they're kind of very focused on context and maybe 20,000 words or maybe sometimes 30,000 words, and to put everything, particularly the introduction part and also maybe the background in a very great detail, but this is definitely not the case for the European journal. So in that regard, it might pose a kind of difficulty for our scholars when they try to prepare for different kind of platform of journals. So I would like to ask if you have ever met such a situation, or do you just need to first secure or locate a journal that you're targeted at, and then you prepare the article, your scholarship, or
Yes.
it is the converse way that you produce something and then to try to find a journal that fits your work? Thank you.
That's I think a very good point and a very good observation. On the one hand, you have the American journals where I, as an academic, I read sometimes the articles and I think like, well, literally, as you said, like the first 20,000 words, I don't need a history of competition law, how the Americans call it, antitrust law. That's not what I need to read. I know that myself. But for those law journals, law reviews, typically student run, that's quite normal. But I think at the same time, what you will see after those 20,000 words is still the same kind of context that you'll have in Europe, a more kind of argumentation, analysis part, or whatever that then makes up the rest of the article. So if you start with that part and you have that part clear, then you can decide, okay, do I want to go for an American one and add all the kind of context, blah, blah, blah. You can do that later. If you are a lucky academic and you have some research funding, maybe you can even get the help of a research assistant. That's not difficult to write. That's summarizing the textbooks that are out there. While the argument, that's the more tricky part. Or you say, well, I'm going to go for a European journal where I don't need to do that. Or sometimes you also find American journals where you don't have to do that. We have a paper on It's called, what is it called? Algorithmic Predation and Exclusion. It's going to be published in an American law journal, and we don't have like huge historical parts in it, even though it's a paper still that has, I think, 35,000 words or 40,000 words. So it's a bit kind of hit and miss, I guess, as well. You need to really kind of think. Some journals they do that, and in American law journals are also different. The submission there, they have a general submission system where you submit to this system and then it gets submitted to a number of journals directly. So it's all slightly different. But I think coming back to, I think one second point that you made is like, do I have the journal first in mind and write then to the journal, or the article? I think I would first write the article and then try to find the journal, and if needed, adjust the paper so it fits the journal. So I think that would be my approach. First, focus on making the writing that you're doing good, easily understandable, and then you can adjust it to the styles. You also know that different journals have different styles of writing in terms of, I don't know, American English, British English, footnotes, blue book, and whatever. So
thank you so much, Professor. Yes, thank you.
My pleasure. Good. If there are no more questions, then I think I bored you now long enough. You have my LinkedIn and email, and you can always email me if there are further questions.
Thank you so much, Julian, for such an interesting webinar. And yeah, we're going to share your LinkedIn and Twitter profile too for people just to follow you and to get to know more about your sharings. And thanks a lot for today.
Thank you, and hope to see you all in person at some point. Bye-bye.
Bye.